The weaponization of trade measures is one of the tools used by populist leaders to reinforce a certain narrative. What is this narrative? It's one where the working class and the middle class in the Western Hemisphere are worse off because of cheaper imports and immigration, deliberately sweeping under the rug key issues such as the dismantlement of the welfare state, a reduction in public investment, deindustrialization, and tax policies.
Are Europe's foundations being tested? Insecurity, digitalization, populism, climate change, gender inequality, pandemics, mistrust. 7 disruptive elements are fundamentally challenging our social pact. This is Rethink the Deal, the official podcast from Express2, the European Union research project dedicated to specifying a more inclusive, democratic and sustainable social contract. Join us as we explore the challenges and solutions shaping Europe's future. Are global trade wars and protectionist pride the new front lines of the populist surge? Today, we unpack how the weaponization of trade policy is reshaping the European social contract. Let's start the conversation.
Welcome to this podcast series, which is part of the activities of Express2 project to specify and protect the EU social contract. My name is Rachele Marconi. I'm a postdoctoral researcher at the Sant'Anna School of Advanced Studies in Pisa, and I will be your host for today's conversation. This podcast is developed within Work Package 5, coordinated by the Sant'Anna School of Advanced Studies and led by Professor Giuseppe Martinico. Our work package focuses on populism as a disruptive factor of the EU social contract. Throughout this series, we will host short conversation with scholars and experts to discuss key themes connected to our research. In recent years, the intersection of international trade and national sovereignty has moved to the forefront of populism studies. This shift occurs as populist movements increasingly recreate trade policy not merely as an economic tool, but as a powerful marker of national identity and protectionist pride. By weaponizing tariffs and trade wars to define the boundaries of the domestic worker against perceived globalist elites, these movements challenge decades of neoliberal consensus and international law, making the expertise of trade scholars and political scientists more vital than ever to understanding our current political landscape. We are delighted to be joined by Dr. Carlo Maria Cantore. Carlo Maria Cantore is an attorney at law, specializing in international and EU trade law. Between 2018 and 2025, Carlo was a legal officer at the WTO Secretariat. In that capacity, he assisted panels in disputes between trading nations and gave advice to members on negotiations and institutional matters. Earlier in his career, Carlo worked for almost 3 years as an associate in the Brussels office of a major trade law firm from 2015 and 2018. In parallel with his work at the WTO and private practice, Carlo has taught international trade law, international investment law, and EU external relations law at the University of Antwerp, Turin, and Neuchâtel. Carlo is the author of a book on trade in financial services, published by Cambridge University Press in 2018, and several articles on trade law and EU law topics. So thank you, Dr. Carlo Maria Cantore, to be here with us today. And let me start with the first question. We are experiencing a dramatic shift toward protectionism and the use of tariffs as a primary political tool. In your experience, to what extent are trade wars a consequence of populist grievances? And to what extent do they serve as a tool for populist leaders to maintain their domestic narrative of us versus them?
First of all, thank you so much for the invitation. It's really a great pleasure for me to be here with you today. And I must confess at the outset that I'm not an expert on populism, so my response to your questions will be based on my personal experience as an individual, as someone who tries to read, to absorb information, and to form his own views on things. My answer to both of your initial questions is to a very large extent. And I think you can see both a bottom-up backlash in the sense of popular movements going against elites and a top-down backlash in the sense of political leaders adding fuel to the flame against international trade liberalization. And this is happening in a way that is not necessarily grounded on solid economic reasons. Now, if we look at the Western Hemisphere and we start chronicling our discussion in the mid-80s, early 90s, the bottom-up backlash against international trade liberalization is an older phenomenon. The Seattle protests, the No Global movement of the late 1990s, early 2000s, were populist reactions from the bottom to the trade liberalization agenda, which at that time was largely supported by mainstream political parties. And we have also experienced throughout the years protests by farmers whose margins were progressively reduced against foreign competition, and workers protesting against the closure of factories and their relocation to countries with cheaper labor and energy costs. But this was happening even though international trade was not necessarily the sole, or even the main in some cases, reason for margins reduction and job losses. So while domestic policy choices in most Western economies were slowly dismantling the welfare state, international trade agreements became an increasingly popular scapegoat. For a long time, however, the grievances of these movements did not get the front seats in mainstream politics. And those with an interest can read, for instance, Destler's American Trade Politics, a beautiful and comprehensive book on all things U.S. politics and trade, if we want to focus mainly on the U.S. Fast forward to the present times, we live in a completely different world, where populist leaders lead mainstream parties, or even more worryingly, populist movements and parties are ahead in the polls and are at the helm of governments on both sides of the Atlantic. And indeed, the weaponization of trade measures is one of the tools used by populist leaders to reinforce a certain narrative. What is this narrative? It's one where the working class and the middle class in the Western Hemisphere are worse off because of cheaper imports and immigration, exogenous causes, deliberately sweeping under the rug key issues such as the dismantlement of the welfare state, a reduction in public investment, deindustrialization, and tax policies systematically relaxed to benefit the few and not the many. And on this latter point, The Power to Destroy by Michael Gratz and The Second Estate by Ray Madoff are must-reads in my view.
Let's focus now on the US case. So as much as populist leaders would like to be above the law, their actions are not immune of scrutiny. The tariffs adopted by the Trump administration have been challenged in US courts, and the issue is currently pending before the Supreme Court. What is the matter, and what are the implications of a decision by the Supreme Court in one way or the other one?
Indeed, we are experiencing a worrying attempt to replace the rule of law with the rule of leader. And our newsfeed gives us many examples of this on a daily basis, unfortunately. And this is also happening in the field of international trade, and the pending case before the Supreme Court is a very important stress test for the U.S. institutional setup. Let's quickly recall the facts. On 2 April 2025, President Trump announced the sweeping increase of tariffs on goods imported from the rest of the world. And I guess we all have in mind the images of President Trump holding a poster in the Rose Garden of the White House. And that poster indicated country-specific increased tariff rates, loosely calculated on the basis of the goods trade deficit between the U.S. and each of those countries due to alleged trade barriers faced by U.S. goods when exported to those countries. In this sense, the Trump administration labeled those duties as reciprocal, a definition that has been heavily criticized by experts. To do so, Trump relied on a statute called the International Economic Emergency Powers Act, AIPA, which gives the executive branch authorities on economic matters when an emergency has been declared, provided that there is an unusual and extraordinary threat to American interests. But if one looks closely at AIPA, there are two major red flags. One, it is meant to be used in response to real emergencies and not as a tool to address perceived trade imbalances or other major long-term economic trends. Second, and perhaps more importantly, nowhere does the statute mention a delegation of power to the US president in the domain of tariffs, a competence that Article 1 of the US Constitution vests Congress with, not the president. And in this respect, the history of AIPA is revealing. 1971, to remedy a deterioration in the US balance of payments, President Nixon ended the gold standard and imposed a temporary 10% additional duty on all imports from abroad. And to do so, it relied on the authority vested with the president in the 1917 wartime statute, the Trading with the Enemy Act. It was a temporary shock, and the surcharges remained in place for a few months only. But that was the first and only time in history until recently when a president used an old war statute to temporarily impose tariffs. As I mentioned, the US Constitution is explicit on the allocation of the competence over tariffs on Congress. And Congress was indeed concerned about the actions of the Nixon administration. And in response to those, it enacted two new pieces of legislation, the Trade Act of 1974 and AIPA in 1977. So these are two sister pieces of legislation that must be read side by side. So the Trade Act of 1974 authorizes the president to impose tariffs to respond to serious balance of payment deficits, massive import increases, actions by other governments that adversely affects U.S. trade. But all this is subject to rigid procedural limits. For instance, there must be an investigation in certain cases, and time limits for the imposition of the measures. AIPA instead authorizes the president to quickly deploy a number of measures, asset freezes, embargoes, sanctions, in the event of an unusual and extraordinary threat, as mentioned before. Now, as one can see, AIPA was never meant to be a legal basis for a U.S. president to impose tariffs, as Congress delegated that power under the narrowly defined circumstances of the Trade Act. Nor can one reasonably hold that the actions of the U.S. president meet the procedural requirements and time limits set forth in the Trade Act, and this is not even the position of the U.S. administration. Now, the stakes could hardly be higher here, and I'll wrap up my answer to your question with 2 points. So first, as one can see, this is essentially a case about the separation of powers, and in a year of midterm elections. Second, because we're talking about money here, we're talking about the economy, should the Supreme Court rule that the AIPA did not authorize President Trump to impose tariffs, importers could file for refunds. Now, the system for the collection of customs duties in the United States is particularly complex, but according to well-informed sources, the bill could exceed $130 billion US.
Moving from the domestic to the international level, what does the WTO have to say about these trade wars? We are increasingly hearing the term weaponization of trade or geoeconomics to describe how nations use market access as a foreign policy lever. How has this militarized approach to commerce affected the WTO's ability to mediate disputes and to perform other core functions?
Well, the WTO does not have a common agent. Let's say there is no World Trade Prosecutor that can go after the WTO's 166 members' trade measures when there is a concern about their compatibility with the agreements. The WTO is a member-driven organization, meaning that its agenda is defined by the members, including on dispute settlement. Now, on paper, the WTO has a pretty advanced two-tier adjudicating system composed of a first instance and an appeal stage. Beginning in 2017, thus under the first Trump presidency, the United States decided to cripple the dispute settlement mechanism of the WTO by systematically vetoing the initiation of a process to replace outgoing appellate body members, a decision that WTO members can only take by consensus. According to the United States, the appellate body of the WTO had engaged in impermissible judicial overreach and had established a de facto binding rule of precedent, something that was not foreseen in the treaties. But between the lines, what you can see here, I think, is one form of legal populism that is becoming fairly common even in our domestic jurisdictions. The attempt, in this case, a successful one, to delegitimize adjudicators. The situation did not change with the Biden presidency. Needless to say, it stayed the same under Trump too. So these are deeply rooted grievances in the US deep state that go further beyond MAGA politics. So what happens now is that 4 disputes out of 5 are appealed into the void, meaning that appeals cannot be heard and first instance decisions are not final. Concretely, even though as lawyers we lack the tools to establish causation with certainty, this also means that members are less inclined to bring disputes to WTO panels at all, and the number of cases brought before WTO panels has in fact plummeted to all-time lows. The EU and other members have established an interim arbitration mechanism to bypass the blockage of appellate body nominations, but key players in WTO dispute settlement have refused to join, at least so far. The United States, of course, but that's also the case of India, Korea, even Indonesia, that has had many disputes, many high-profile disputes with the EU in recent years. And in any event, only 2 disputes have been adjudicated under this interim arbitration mechanism since 2020. Not the definition of a success. In response to the blatantly WTO inconsistent measures adopted by the United States, commentators have argued, correctly in my view, that the right course of action would have been for members affected by these measures to collectively take the US before WTO panels. But only Brazil and China have taken first steps, and by the way stopped at the very first step, at the request for consultations. They didn't even request the establishment of a panel, which is an indication of an intention to pursue one's case. So most members have instead rushed to Washington to negotiate deals, obtaining slightly reduced import tariffs compared to the Rose Garden announcement, and even calling it a win, adding insult to injury. And by the way, these deals also constitute egregious violations of WTO law. So members have de facto caved in to the rule of power, and this is a remarkable step back for a dispute resolution system that used to be the most advanced in public international law. The other 2 key functions of the WTO, because you also mentioned core functions of the WTO in your question, are negotiations and the monitoring of trade policies. The latter used to be more important in the past, where the flow of information was lower and language barriers were higher. It continues to function, but it does not really move things. And the negotiating function, however, is broken and needs to be fixed. The WTO DNA is one of an organization that makes decisions by consensus. And as such, it takes one member only to block the conclusion of negotiations on meaningful new rules. This even applies to agreements among a subset of members only, so-called plurilaterals, which need the consensus of the entire membership to be added to the WTO rulebook. Now, even agreements that cannot be seriously defined as ambitious are stuck, being at the mercy of a handful of veto players. So consensus does not really work, and members should get creative and find workaround solutions. But this is not going to happen without a leader. Bottom line, the WTO was established at a time when one superpower had emerged as the clear leader. But now the United States is retrenching, and the WTO is navigating without a leader. As a European citizen and as a firm believer in the EU project, I was hoping that the EU would at least try to play a part, if not claim leadership for itself. But what we've seen in the last months, however, is frankly demotivating. Think of the Turnberry surrender to virtually all US requests on trade, and the hard-to-understand position of the EU Trade Commissioner, who recently called for a rethinking of the most favored nation principle, that is the prohibition on discrimination based on the origin of the goods, on the basis of reciprocity.
Turning now to our last question, the EU-Mercosur agreement has faced fierce opposition from both the political extreme left and right in Europe, often for very different reasons, from environmental concerns to agricultural protectionism. Why has this specific agreement become such a lightning rod for populist rhetoric? And what does this tell us about the future of large-scale multilateral deals? Can you tell us something about the European Parliament's request for an opinion by the Court of Justice and its implications?
Virtually every free trade agreement faces similar opposition these days, and the EU-Mercosur FTA is no exception in this respect. In this case, however, an agreement whose importance cannot be overstated risks being abandoned due to a very well-organized, loud minority. Protesters in the EU targeted essentially two aspects of the agreement: environmental concerns and the threat of cheap agricultural imports flooding the EU market. But on environment, the agreement is more advanced than most other trade agreements, as it includes commitments to implement the Paris Climate Agreement and to tackle deforestation. And on agricultural and farm products, tariffs on imports in the EU will effectively be reduced, thus stimulating competition from abroad. But when it comes to sensitive products, where competition for EU domestic products could be more intense, think of poultry, beef, and the tariff reductions will only apply to imports from Mercosur countries up to a volume of less than 2% of the EU total production of the same products, and largely in line with historical market shares. In addition to this, a safeguard mechanism was introduced to allow for quick reactions in the event that sudden spikes in imports cause serious injury to domestic producers of a given agricultural product. What protesters don't say, however, is that the agreement offers great opportunities for EU producers and services producers when exporting their goods and services to Mercosur countries. If we just limit the analysis to the agricultural market, the agreement protects hundreds of EU geographical indications, thus shielding EU producers from unfair competition and counterfeiting in Mercosur countries. Not to mention the huge opportunities for EU wines, other farm products currently subject to high duties that will be reduced in a market such as that of Mercosur countries, where many second or third generations Europeans live and have great interest in purchasing European products. What is more worrying compared to the protests, however, is the reaction to these protests by political leaders in the EU. Think of the Italian government, which delayed the signature of this landmark deal because it was under pressure from one farmers' lobby with strong ties with Prime Minister Meloni's party. Eventually, the Italian government gave the green light, and that allowed the EU to have a sufficient number of member states backing the agreement. The situation was even worse in France, where politicians from across the entire political spectrum did not resist to pressure from lobbies. And to me, this is not just about a trade deal. This is a warning sign and a symptom of a very fragile political system which caves into protests from fringe movements, and this is going to have severe repercussions on the institutional setup of European states and the European Union. Now, one could have thought that after the green light from member states and the signature of the agreement by EU and Mercosur countries, all was under control. And yet, something happened in the European Parliament, as you said. At the request of a heterogeneous group of MEPs, the European Parliament, by a tiny majority, voted to request that the EU-Mercosur agreement be sent to the Court of Justice for it to give an opinion on its compatibility with EU treaties. From an institutional point of view, requesting an opinion is certainly a prerogative of the European Parliament. Concretely, however, this was just a way to try and delay the entry into force of the agreement, given that the court will not render an opinion before mid-2027 at the earliest. And if one looks at the issues raised by the European Parliament against the background of EU treaties and the consolidated case law of the Court of Justice on these points, while the possibilities of a negative opinion by the court range from small to inexistent. and the proponents of the request for an opinion certainly know it. But there is an interesting twist to this story. The decision of the Council approving those parts of the agreement that fall exclusively under EU competencies mandates the provisional application of the agreement, of that part of the agreement, pending its entry into force, in the event that just one signatory Mercosur state notifies the EU of its readiness to also provisionally apply the agreement. So it takes one Mercosur state to be ready to trigger this clause. And there are indeed calls and this can happen by already this spring. Now we are seeing already calls by EU leaders, including Chancellor Merz of Germany, to swiftly proceed with the provisional application of the deal without delay. The stakes here are very high, as this would lead to an unprecedented confrontation between EU institutions, the Council and the Commission on one end, and the Parliament on the other end. But from a technical, legal standpoint, I believe that the EU-Mercosur FTA can, and even should, if you ask me, be provisionally applied, even while the opinion of the court is still pending.
Thank you very much, Dr. Carlo Maria Cantore, for turning in. And we hope you enjoyed this deep dive into populism and trade wars. Don't forget to subscribe so you don't miss our upcoming discussions. And we'll see you in the next episode.
Thank you for joining us on this episode of Rethink the Deal. We hope our insights on the challenges facing the EU social contract inspire you to join the debate. To ensure you never miss our next discussion, please subscribe and follow the Express 2 project online. This podcast series is part of the Express 2 research project, funded by the Horizon Europe program.